afternoon, everyone. Thank you so much for joining this MSBA webinar on Loper Bright and Corner Post implications on Maryland administrative law. My name is Lisa Blitzstein. I'm a section council member with the Environment and Energy section, and I will be moderating the event together with Kenny Davis, who's also on section council for the Environment and Energy section, as well as the chair of the Administrative Law section, Valerie Green. I first want to introduce our speakers for this afternoon and then just give a very brief bit of background on the two cases before turning it over to them. This afternoon, you'll hear from Joshua Auerbach, Matthew Claggett, and Roy Prather. Joshua Auerbach from 2007 to 2024 served in a number of positions in the Office of the Attorney General of Maryland. As principal counsel to the Department of Health from 2011 to 2015, Josh advised the department on wide-ranging matters, including the implementation of the Affordable Care Act in Maryland. As a special assistant to Attorney General Brian Frosch, Josh served as lead counsel in affirmative litigation and coordinated legislative projects focused on protecting vulnerable Marylanders in the health system and in complex financial transactions. He has argued more than a dozen cases in Maryland and federal appellate courts, many of them involving novel issues of administrative law. In recent years, Josh has also taught administrative law and civil procedure at the University of Maryland Carey School of Law. Matthew Claggett joined the Office of the Attorney General in 2017. He advises the Maryland Department of the Environment's Water and Science Administration on a variety of matters of state and federal water law. He previously worked for the County Attorney's Office in Charles County, Maryland, representing the county in land use planning and zoning, administrative and environmental law, and more. Matthew was also awarded a National Research Council Fellowship to join an EPA research team developing a pilot project to reduce stormwater runoff using economic incentives. While at EPA, he also counseled agency scientists on impacts to their wetlands research programs in light of the Rapinos v. United States Supreme Court decision, and served as an adjunct professor at the University of Cincinnati, teaching environmental law and policy to graduate and undergraduate students. Roy D. Prather III is a partner in the Baltimore office of Beveridge and Diamond, an environmental law firm. He represents businesses and municipalities in federal and state courts and in environmental and commercial litigation. He defends citizen suits and class actions involving toxic tort and product liability claims under federal environmental laws and state analogs, including the Resource Conservation and Recovery Act, Safe Drinking Water Act, Clean Air Act, and Clean Water Act. He also represents clients in class actions and other consumer protection litigation involving green marketing and related allegations of greenwashing, and he advises clients on issues relating to regulatory compliance. Before we hear from our esteemed presenters this afternoon, by way of just a very brief bit of background on Loper Bright and Corner Post. In 2023, the Supreme Court's 6-2 ruling in Loper Bright was, the Administrative Procedure Act of 1946 requires courts to exercise their independent judgment in deciding whether an agency has acted within its statutory authority. Courts may not defer to an agency interpretation of the law simply because a statute is ambiguous, and thus Chevron v. Natural Resources Defense Counsel is overruled. The facts in Loper Bright were that the National Marine Fisheries Service under the Department of Commerce promulgated a rule that would impose a requirement for at-sea monitoring programs on marine fisheries. Under Chevron, the court previously deferred to agency interpretations of ambiguous statutes if those interpretations were reasonable. In overruling Chevron, the court said that the APA requires courts to decide all relevant questions of law when reviewing agency actions. This means courts should use their own judgment to interpret laws, not defer to agencies' interpretations. The court justified declining to follow stare decisis because Chevron is flawed in its reasoning, unworkable across cases, and has not, quote, fostered meaningful reliance. The decision did not overrule other decisions which used Chevron. The court said that reliance on Chevron did not alone constitute a special justification to overturn those cases. And in Corner Post, the 6-3 court held in 2024, an APA claim does not accrue until the plaintiff is injured by final agency action for purposes of 28 U.S.C. Section 2401A, which is the default 6-year statute of limitations applicable to suits against the United States. Their regulatory agency, the Board of the Federal Reserve System, promulgated a rule in 2011, imposing a cap on the interchange fees that banks can charge businesses for debit card transactions. Initially, 2 trade associations in North Dakota brought the suit to challenge the rule as being arbitrary and capricious under the APA. In response to a motion to dismiss by the board based on the 6-year statute of limitations, the trade associations added Corner Post, a truck stop convenience store that formed in 2018, as a plaintiff. The court declined to follow the federal circuits, which hold that the limitations period for facial APA challenges begins on the date of final agency action, for example, when the rule was promulgated, regardless of when the plaintiff was injured. Instead, the court said that following the, quote, standard rule for limitations periods, an APA plaintiff does not have a complete and present cause of action until she suffers an injury from final agency action. So the statute of limitations does not begin to run until she is injured, unquote. Thus allowing Corner Post to challenge the 2011 rule within 6 years of when the business, formed in 2018, actually suffered an injury. So with that, today our presenters will give their perspectives on how these rulings impact the direction of administrative law in Maryland. Each of them will have the opportunity to speak for a few minutes, and then we'll turn to questions and discussion. As Valerie said, you're encouraged to put questions in the chat throughout the event, and she'll moderate so that we can provide your questions to the presenters. So with that, I'd like to pass to our presenters, and that will be starting with Joshua Auerbach. Take it away.
Thanks very much. Hello, you all. And I see a bunch of old friends out there. And thanks, Lisa, for the introduction. Thanks to you and your colleagues for allowing me to participate today. I'm really looking forward to the discussion, and in part because it comes, of course, at another incredibly interesting moment in the development of administrative law in this country. I taught administrative law this fall at the University of Maryland School of Law, in the wake of a Supreme Court term that, as Lisa explained, fundamentally reshaped the subject. And beyond Loper Bright and Corner Post, there's also the Jarkissi case, which many of you have read and thought about. And then there are a bunch of other cases that maybe were not quite as paradigm shifting, but that were really quite important. I'm thinking in particular of the case called Ohio versus EPA. So it was a very interesting challenge to teach the subject that where the ground had shifted so profoundly over the summer. The world has turned a little bit now. Maybe we've forgotten all about what happened last year. Maybe now we're all about Humphrey's executor and impoundment. But as recently as a couple months ago, these cases, and Loper Bright in particular, were a really big deal, and they will be again. And so let's looking forward to talking about them today. When I taught this fall, those of you who are about my age will remember the movie Dead Poets Society, and the case book I assigned had 1,500 pages in it. 200 pages were devoted to the Chevron framework. And so, for those of you who remember Robin Williams and Dead Poets Society, I was very, very tempted to come into class on the first day and say, there'll be nothing but ripping of Chevron. I restrained myself from doing that. But that's the significance in casebook page length terms of Loper Bright. And so I thought I'd focus my opening salvo here on Loper Bright in particular, and on what I consider to be probably the most important set of problems that Loper Bright is addressing. And that's the set of problems associated with what I'm going to call mixed questions of law and policy. It's not a particularly creative term, not original. What do I mean by it? I mean a question involving the interpretation of a statute of ambiguous statutory language, where the interpretation of the statute seems to involve, at least in part, the resolution of an issue of public policy or the exercise of policymaking judgment. And I thought I'd just contrast how the Chevron court thought about those problems, how the Loper Bright majority thinks about those problems, and how the Maryland courts seem to think about these problems. And so I have a PowerPoint here, a brief PowerPoint, which I'll attempt to share. May not get through all of this, my famously wordy PowerPoint slides, but this is sort of setting the table for the discussion. And the core problem, of course, is the agency has taken some action. It has promulgated or amended a set of regulations. It's taken some enforcement action. And a challenger says that the agency's action is contrary to the statute under which the agency says it's acting. And for a long time, our law has recognized, and indeed the Federal Administrative Procedure Act itself recognizes, that sometimes these issues are not exclusively issues of law or even principally issues of law. Rather, sometimes these issues, even though they may present on the surface as issues of statutory interpretation, are principally presenting a question requiring scientific or technical expertise or questions requiring policymaking judgment. And I'm going to focus on the latter of those. And that's where Loper Bright, I think, most unsettles the doctrine. Where does the federal APA recognize that agency action often involves the resolution of these mixed questions of law and policy? Well, for example, in the definition of the term rule in the APA. A rule is defined, among other things, as an agency statement designed to implement, interpret, or prescribe law or policy. And interestingly, I don't have the whole definition here for you, but the definition doesn't seem to attach much significance to the difference between law and policy. The terms seem almost to be interchangeable here. And as the statute goes on, it doesn't give any guidance in how to distinguish between these two things. Why not? Well, the reason might be that it's really hard to do that in practice. The Loper Bright majority may beg to disagree. We'll talk about that. But it may or may not be able to disentangle the law part from the policy part. In the Chief Justice Roberts, in his majority opinion in Loper Bright, arguably acknowledges in a couple places the existence of these mixed questions of law and policy, but only, let's say, reluctantly. For the Loper Bright majority, as Lisa said in her introduction, the question is who gets to do statutory interpretation? And the answer is, of course, that judges do statutory interpretation, not bureaucrats, not agency officials. But beyond that, the Loper Bright majority keeps it pretty abstract. That doesn't go very deep in telling us how to unpack these questions in real life. Meanwhile, many of you will remember that Justice Kagan's dissent takes very much the opposite tack. She opens her dissent with this bullet point list of real life examples of statutory interpretation questions that agencies resolved. And all the questions on our list, again, though they present on the surface as issues of statutory interpretation, all seem to require either some very serious scientific or technical expertise or some very serious policymaking judgment. And Justice Kagan kind of challenges the majority to explain how the courts should deal with those questions in real life. And Justice Kagan's bullet point list includes the Chevron case itself, where, as you all may remember, the question was whether during the Reagan administration, the EPA could interpret the statutory term stationary source as used in the permitting provisions of the Clean Air Act, such that the term would be understood going forward to refer to an entire industrial plant rather than each individual smokestack within the plant. And as a result, that would allow certain changes to plants without the need for the plant's owners to seek a permit. And Justice Kagan thinks, I would submit, this is a great example of a mixed question of law and policy. The text and legislative history of the Clean Air Act didn't really reveal whether the term stationary source could be read in that way. And so, unsurprisingly, the EPA interpreted the term in accordance with its view of how best to achieve the statutory objectives of protecting the environment without unreasonably constraining economic growth. And maybe also, unsurprisingly, the Reagan administration EPA came up with a different interpretation of the term than the Carter administration EPA did. Another famous example, this one's actually mentioned in the Loper Bright majority opinion, is a case that many of you will remember from the 1940s called NLRB versus Hearst Publications, which involved the NLRB's determination that the so-called newsboys were employees. That was the statutory term for purposes of the collective bargaining rules imposed in the NLRA, the National Labor Relations Act. And newsboys were, in fact, mostly adult men who sold newspapers on the street. And Chief Justice Roberts says that the newsboys case, in sort of explaining why there was some deference accorded by the Supreme Court, that the newsboys case involved a so-called fact-bound determination. But in reality, there doesn't seem to have been much in dispute about the facts of that case. The facts were, as presented in the Supreme Court opinion, were pretty much undisputed about what the newsboys did, about how they got paid, about how much supervision they got from the publisher. And the core of the question was whether it would be good industrial and labor policy to treat these workers as employees for purposes of collective bargaining. So that's what we're talking about here. And these types of questions, just at the top level, raise some pretty interesting separation of powers problems. Which branch of government should be the one legitimately that resolves these issues? The courts are not supposed to make policy. The political branches of government are supposed to make policy. And on the other hand, the courts do law. And then there's also the question of competence. The NLRA, the NLRB knows something about industrial and labor policy, and the Supreme Court may not know as much. So the questions are, under our constitutional framework, who should be making these calls and who's good at making these calls. And so what I want to do is just look, I know I'm short on time here, I want to look quickly at three different approaches to this set of problems: Chevron, Loper Bright, and Maryland administrative law. Chevron was fixated on the problem of mixed questions of law and policy. And Chevron, of course, adopted a very strong presumption that when it comes to the resolution of these questions, judges should stay out of policymaking. The language I got on the slide here appears at the end of the Chevron opinion. And Chevron said, when a challenge to an agency construction of a statutory provision fairly conceptualized really centers on the wisdom of the agency's policies, rather than whether it's a reasonable choice within a gap left by Congress, the challenge must fail. In such a case, federal judges who have no constituency, here we're on the institutional legitimacy problem, have a duty to respect legitimate policy choices made by those who do. The responsibilities for assessing the wisdom of policy choices are not judicial ones. So here, the court is saying pretty clearly, judges don't make policy. It's not our job under the Constitution. It's not legitimate for us to make policy because we're not accountable to the people. And by contrast, federal agencies are answerable to the president, who's the only official in our government elected by all the people. And, and so in Chevron itself, where the Reagan administration EPA decides that the term stationary source means the whole plant rather than the individual smokestacks, and where there was nothing in the statutory text or legislative history to tell the court whether that interpretation was right or wrong, the court's job was to let the EPA decide that issue as long as it did so in a reasoned way and in accordance with its own view of good environmental policy. There's another important idea, a kind of jurisprudential idea, I think implicit in the language on the slide here. And that's the idea that when an ambiguous statute presents a mixed question of law and policy, there's only so much that judges can do to separate out the law part from the policy. So for the Chevron court, in reviewing the EPA's decision about what the term stationary source means, there's very little that a court can say without treading into the domain of policymaking. Important to acknowledge, Chevron isn't saying that there's nothing a court can do. The boundaries, you all may remember, are boundaries of permissibility. The Chevron court says that The court's job is to determine whether the agency's interpretation of an ambiguous statute is permissible. But at least under the broader understandings of Chevron, um, that's a very limited role. And so the combination of these two ideas, one, that our paramount concern is judges don't do policy, and two, that it's hard to separate out the law apart from the policy part, yields a very strong form of deference. Um, and we're going to accept that if we're deferring to agencies on these questions, that in practice, the agencies are going to be doing a lot of statutory interpretation. They're going to be deciding a lot of issues of law. So now let's fast forward 40 years. What I want to emphasize about Loper Bright is that with respect to these mixed questions of law and policy, the majority comes down on the opposite side of Chevron on both of the questions we've just been discussing. The separation of powers issue and the jurisprudential issue. That is to say, first, Loper Bright's paramount separation of powers concern is not that a court might decide a question that has big policy implications, but rather kind of the reverse of that concern, that a court might be displaced from deciding a question of law. We all know, as Chief Justice Marshall said, it's the province of the courts to say what the law is. And Chief Justice Roberts is saying in Loper Brights that from a separation of powers perspective, what we want most is to avoid agencies taking over that job from judges. And beyond this is really a striking reversal. Beyond this reversal on the separation of powers theory, Loper Bright is also saying that Chevron had its kind of jurisprudence wrong. When you get a mixed question of law and policy, Chief Justice Roberts tells us, there's always an overarching question of law for the court. Moreover, the law part of the problem is much bigger under the Loper Bright way of thinking than it was under the Chevron way of thinking, because we're all textualists now. And as textualists, we believe that we can extract definitive meaning even from ambiguous statutory text. And relatedly, the Loper Bright majority has much greater confidence in the ability of judges and those so-called tools of statutory interpretation to separate out the law from the policy. And so here's what the court had to say about that. I got on the slide. To stay out of discretionary policymaking left to the political branches, judges need only fulfill their obligations under the APA to independently identify and respect congressional delegations of authority, police the outer statutory boundaries of those delegations, and ensure that agencies exercise their discretion consistent with the APA. And just that simple. And of course, this is, I think, language that probably directly responding to the language we saw in the last slide, and these concerns about the line between and the judicial role in policymaking. Clearly, we're in a this is one of a couple points in the Loper Bright opinion where the majority acknowledges the existence of our mixed questions of law and policy, but clearly we're in a very different world from Chevron. And I should say, though, that while what the court is saying as a theoretical doctrinal matter here is pretty clear, what it means in practice when it comes to the resolution of the questions like the one in Chevron and like the other ones that Justice Kagan highlighted in her dissent, or like the question whether the newsboys are employees under the NLRA, we're gonna have to wait and see what that means in real life. Chief Justice Roberts is not taking the bait from in Justice Kagan's dissent, not telling us too much about how this might look in practice. The Loper Bright approach is easy to articulate, maybe not so easy to apply in real cases. We might get a first glimpse of what it looks like, what the post-Loper Bright world looks like in a currently pending case called Wages and White Lion versus FDA that some of you may be following, where the Supreme Court is reviewing the FDA's denial of a company's application to market certain e-cigarette products, and where one issue appears to be the degree of policymaking discretion that the relevant statute delegated to the FDA. The important point for now is that, while the doctrinal impact of Loper Bright is really quite enormous, involving the ripping out 200 pages from my casebook. The practical implications are far more uncertain. I just want to make two more quick points about Loper Bright. One is that the effect of this is to raise the stakes of the judge's determination on judicial review of whether the agency was engaged in law or engaged in policy. Previously, under Chevron, um, we have a deferential approach to review of agency statutory interpretation, and that means that approach has a fair amount of affinity with arbitrary and capricious review of agency reasoning. You have kind of so it doesn't make a lot of difference whether we're calling what the agency did law or policy. Now, um, it will at least in theory make a lot of difference. The other last point about Loper Bright, there are a number of places in the opinion where the majority refers to constitutional limits on delegation. And although there's no elaboration of that language in Loper Bright, the majority is, of course, referring to the non-delegation doctrine. Not going to talk about non-delegation at any length here, but of course, one of the, um, you know, important to recognize that one of the great pending mysteries in administrative law is whether there's presently a majority on the Supreme Court to jettison the intelligible principle test, to greatly expand the non-delegation doctrine and make it a really significant limit on the ability of Congress to delegate policymaking authority to agencies. And we know that Justices Thomas and Gorsuch want to do that. Chief Justice Roberts has said at times that he wants to do that, although he's passed up the opportunity to do that a number of times now too, including in Loper Bright. Remember, Loper Bright is a decision that interprets the Administrative Procedure Act, and it does not. It's not decided as a constitutional matter. And Justices Alito and Kavanaugh have said they may be inclined to do this. And so in the future, when there's a mixed question of law and policy in a case, um, you know, the 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 first response may be that that Congress shouldn't have delegated that policymaking authority to the agency in the first place. And okay, just a minute on Maryland. The bigger overarching point for me, and I'm thinking there will be agreement on the panel with respect to this one, is that the Maryland courts never embraced the Chevron framework. And in part for that reason, it's somewhat unlikely, at least in the short term, that the Maryland courts are now going to adopt the Loper Bright framework. I would say over the last few years, seemingly in kind of full awareness of what the Roberts Court has been doing in federal administrative law, the Maryland Supreme Court has been engaged in what we might call a kind of restatement of Maryland administrative law. And Justice Booth has been the author of many of these opinions. We've also heard from a number of the other justices. And my own view of what these cases do, we'll be interested to hear what Matt and Roy think, is that they modernize some of the terminology that the court is using. In certain respects, they harmonize Maryland law a little better with federal administrative law. For example, the recent cases compare Maryland's approach on our issues here to the approach sketched out by the U.S. Supreme Court in Skidmore from the 1944 Skidmore case, which is an approach that Loper Bright has kind of revalidated. But having said that, these recent decisions, I don't think, have made major changes in Maryland administrative law. And while there's some harmonizing going on with federal law, for the most part, our Supreme Court, it seems, is continuing to chart its own course on key issues like the ones we're going to be discussing, and has not by any means been adopting federal administrative law wholesale. So where are the courts on these issues? Maryland courts. First of all, they seem to recognize the kinds of mixed questions of law and policy that we've been discussing. Often the Maryland courts refer to these questions where they seem to be principally matters of policymaking as matters committed to agency discretion. For you the true administrative law nerds out there. The federal APA, of course, also refers to matters committed to agency discretion, but the term means something quite different and much narrower in federal law. Essentially, in federal law, these are matters that don't belong in court at all, and therefore can't be the subject of judicial review. Um, on the separation of powers, anxiety, concern, I would say that the Maryland court's thinking has been much more in accord with Chevron um, than with Loper Bright, in the sense that the Maryland Supreme Court has been deeply concerned about judicial engagement in policymaking. And there's plenty of language articulating that concern in Maryland cases. On the other hand, our courts seem to have some confidence, as the U.S. Supreme Court did in Loper Bright, in the ability of judges to kind of go statute by statute and determine the precise amount of discretion the General Assembly delegated to the agency in a particular case. And the court reaffirmed this idea just last year in an opinion authored by Justice Booth. Um, and so, and I guess I would say the last point here. I mean, the court has also articulated a view of non-delegation that's very similar to the view that's prevailed in federal court about non-delegation over the last century. And unlike in the U.S. Supreme Court, there isn't evidence at the moment of any inclination of our court to rethink non-delegation doctrine.